Welcome to U.S. Visa Questions Answered Here.
Welcome to U.S. Visa Questions Answered Here with Immigration Attorney Frances Hayden. For decades, Frances has focused on consular processing of non-immigrant visas at U.S. embassies and consulates worldwide, with a special emphasis on third country national visa processing. I'm your host, Sophia Morales, and today's episode is Visa Denials, Understanding the 214B and What to Do Next. Welcome, Frances. I'm so happy to have you back with us today.
Thank you, Sophia. I'm happy to see you again.
So what does it mean to be denied under Section 214B of the Immigration and Nationality Act?
Well, that section of the law is a general denial. We kind of call it in some ways it's a less serious denial because it doesn't contain any kind of bar on future applications, or you're not ineligible permanently to enter the United States. So in that sense, it's good. It's temporary. It's misunderstood by a lot of people, including attorneys, because it has two components. The first component is the one that most people know about, which is you haven't overcome the presumption in U.S. law that you are intending to immigrate to the United States. We think we're so wonderful that everybody wants to come here.
It's a very American point of view.
And that's what everybody knows about when they say 214B. And many attorneys go for many years of their career, including me in the beginning, thinking that's all it is. But that's not all it is. It's also used as a general denial. And so that can mean that the consular officer doesn't think you're going to use the visa as you're supposed to, or that just in general, whatever presentation of the facts that you gave isn't good enough that you can be approved for it. Like, for example, if you're getting an extraordinary ability visa, you have the petition approval from the Immigration Service back in the United States, but when they look at you, they think, well, I don't think you're that special. I think immigration made a mistake in approving your petition, so I'm going to deny you under Section 214B.
Wow, okay.
It doesn't necessarily have anything to do with your ties to your home country. Many times it does, but many times it doesn't.
Isn't that interesting? And is there any way to tell what the government is really concerned about when you get one of these 214Bs back?
It's a major frustration of mine and of my clients that it's really hard to suss out what happened. The first thing I do when I talk to somebody who has had a 214B denial is to ask them exactly what was asked and answered at the interview. Basically, like I have them write me a dialogue of exactly what happened and also which documents that the officer looked at. And through that, I try to make an educated guess as to what went wrong. The applicants sometimes have an erroneous impression of why they were refused.
Okay.
And it's so generalized that it's like a boilerplate notification that they hand you that just says 214B. And oftentimes it'll say that language about not having proved your ties to your home country or not having overcome the presumption. However, it could be something beyond that. It could be the other part of 214B that I mentioned, nothing to do with the intention to immigrate. So it's a very mysterious, murky area, and we have to make our best guess.
Okay. So if we're denied under 214B, can we reapply, and what should we do differently?
Well, the normal standard is that the consular officer wants to see something different than you submitted last time. So they often couch that in the phrase, change circumstances. But many times I help people apply again, even when they haven't had changed circumstances, but they have a change in the way that they're explaining their case.
Their circumstance. Okay.
Right. They're explaining their circumstance differently and usually I take the approach that it wasn't the officer's fault, but I didn't present my information properly, and I want a second chance to clarify the information that I presented before.
All right. That sounds reasonable to me. So having one of these denials on your record, does that affect your chances of success on future applications?
A 214B denial does not technically create a legal bar to you getting the visa the next time. There are some kinds of denials we can talk about another day that do. For example, if you're accused of fraud, that can create a lifetime bar. That's a subject for another podcast. But 214B in and of itself is, as I say, a soft refusal. The only remedy is to reapply. The problem and the way in which it affects you going forward is, number one, you must disclose it on the DS-160. Sometimes people try to get away with not disclosing it. What they don't realize is that it's in the worldwide system. It doesn't matter where you go, it's going to follow you. And the same is true for the notes of the consular officer who refused you, outlining their reasons for their decision. So in that sense, it does create a problem in the future. Not saying it can't be overcome. Many 214Bs have been overcome, but there is a bias towards another denial. It's as if it creates a momentum towards another denial, in part because the new consular officer that is making the decision often will want to respect their colleague's decision in your case and not stick their neck out and make a contrary decision.
Boy, you'd really like a peek at those notes, huh?
Oh, yes. They're very much not available to us. And
darn.
We try to get them. We can't.
Okay, very good. Well, not very good, but at least we know. So
yeah, that's why you want to avoid the first denial.
Yeah, and get it right the first time,
That's
which
correct.
means get an immigration attorney on your side.
Yeah.
So how important is the role of documentation when you're trying to overcome this presumption of immigrant intent?
Well, we've talked about this before. Documentation is generally not trusted by consular officers because they believe that documentation can be falsified, which unfortunately is true.
Well, and it's gotten easier and easier as technology advances.
AI, right?
Yeah.
So there are so many cases of documentation being false and people selling documents outside the consulate or embassy, all kinds of crazy stuff. So the consular officers really are going to go by what you say on the DS-160, which is super important, especially in the case of a denial, because if you've been previously denied on the electronic visa application form, a little box, when you say, yes, I've been denied, it'll say explain, and you have a box there to talk to the consular officer in a way that you don't get when you're standing in front of them, because they usually just want to ask and answer. So in that box, you have the opportunity to state your case briefly, but state your case. That is better than any documentation you can present, in my opinion. They're going to go by that. And they're also going to go by, what do you say? So it is valuable to have an attorney prep in a circumstance when you've been denied previously, to be able to couch it correctly in the language that the consular officer will understand, to explain things in a way that will not lose your credibility, to not blame other people if there's something that needs to be explained, but to take responsibility for it. It's helpful to talk to somebody who kind of knows what the consular officer is thinking, which is what an immigration attorney that does consular processing should know. So the documents, yes, we have to bring them to answer your question directly. You still have to be prepared. Like if you failed to bring proof that you have had a job for a while, then, that's going to hurt you. If they ask you, well, let me see your pay stubs, or let me see a letter from your employer. It is important to have the documentation. 9 times out of 10, they're not going to look at it.
Well, okay, better to have it and not need it.
Absolutely, yes.
So what advice do you give clients who are feeling frustrated or discouraged by having gotten one of these vague 14B denials?
It's hard, depending on the case, because in some cases I've actually told people, don't try again right now, because the facts cannot be changed. The facts of your situation don't justify an approval, such as you've only just arrived in the place where you're living and you were living, say, outside the United States, or you were in the United States for a long time on a visa, maybe legal or illegal, and you've just come back and you haven't established ties. Okay. Generally speaking, you need to have had either a job or school for at least a year before you apply for the visa, to show that you have some stability. Yeah. It's helpful, though not 100% a guarantee you'll be approved. If you have family in the country where you're coming from, and you can articulate a good reason for coming back. So if somebody comes to me that has been staying in the United States for 6 months at a time on a visitor visa, coming and going, and not really able to show how they supported themselves in their home country, that's a bad indication. If they don't have a steady job or they just got a steady job recently, I say, why don't you wait until you have a better profile, better facts in your case. In some cases, I can see directly that there was a misunderstanding or a mistake, and really the person is approvable. And in those cases, I tell them, hope is not lost. You can try again. Here's how you can try again and have a better chance next time.
Very good. And what are the steps you take as you guide someone through the reapplication process so they've got that better chance?
Well, the number one important thing is to fill out the DS-160 with a clear explanation of why you think you were denied last time, and to reveal the refusal. Because if you try to hide it, you lose your credibility.
Yeah,
so that's
exactly.
Number one thing, fill out the application again, make it consistent with your last application, but add in, as I say, that little box that opens up. In some cases, people who are applying have had a situation where they were refused entry to the United States on a previous visa, for example.
Oh, okay.
Yes. I deal with those situations frequently. And if you're refused entry when you apply for the next visa, it's another thing that you have to reveal besides a visa refusal. So you need to answer the question, was your visa ever canceled? And did you ever get denied entry to the United States or withdraw your application for admission? Those have different legal distinctions. The denial of entry creates a 5-year bar. So if you're going in under those circumstances, you need to be ready to ask for a waiver. Again, a subject for another conversation. So the steps are basic steps similar to how you applied the first time, just with hyper awareness of what you're saying and how you're going to communicate the situation to clarify what the problem was last time.
Well, thank you so much for all of this insight today, Frances.
Absolutely, my pleasure.
Thanks for joining us on U.S. Visa Questions Answered Here with Immigration Attorney Frances Hayden. We hope today's conversation gave you clarity and confidence as you navigate the immigration process. If you have questions or need legal support, visit haydenimmigrationlaw.com to schedule a consultation. Remember to subscribe, rate, and review the show. Your support helps others find the guidance that they need. And until next time, take care and stay empowered.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.